Very good morning to our esteemed panelists, the presenter for the day, and our most importantly to our welcome. So gone are those days when there used to be a misnomer that the company secretary or consultants of an unlisted company are not that burdened with compliance. Nowadays, with the repetitive ROC orders and the numerous cases of operation mismanagement, the role of a company secretary and consultant of an unlisted company has become even more important. And in this ever changing legal and compliance structure, we at Mehta and Mehta thought what better a topic to take than governance in board meetings from an unlisted company perspective, specifically covering the secretarial standards one related to the board meetings. This is what comes to our safeguard whenever there is, as a company secretary, whenever there is any allegation or governance issues in the company, the secretarial standards and compliance with the acts as a safeguard for us. So today we have with us our panelists, Mr. Anil Khatri, sir. Mr. Anil Khatri is an accomplished company secretary with over 38 plus years of experience across the IT services and manufacturing industries. He's currently serving as a chief advisor at Mehta and Mehta. He previously held the position of vice president and company secretary at Tech Mahindra Limited for 14 glorious years. He brings proven expertise in corporate governance, mergers and acquisitions, and regulatory compliances with a strong ability to navigate complex regulatory environments. He has a demonstrated track record of building strong stakeholder relationships and liaising effectively with SEBI stock exchanges and leading legal and accounting firms. Adept at risk management, strategic advisory, and vendor oversight. He consistently delivers value driven guidance at the highest levels. Welcome to you, sir. We have our presenter for today, Ms. Sakshi Gupta, our partner from Jaipur. Sakshi is an associate member of ICSI and has completed her bachelor's in commerce and law. She has worked with Multi Commodity Exchange of India Limited and has experience in the fields of incorporation of companies, LLPs, increase in capital, conducting board and AGMs compliance, SEBI LODR, stock exchanges and clearing corporation regulations, and the PIT regulations. Currently, she is our partner from Jaipur. And as always, we have with us Balakrishnan, sir, Professor Balakrishnan, who moderates our Saturday webinars and comes with a rich experience from the Fosco India Limited, where he was a company secretary and compliance officer. And welcome to you, sir. And we also have our very own Sudhakar sir, a name that is well known, not just at Mehta and Mehta, but I think all across the fraternity, the company secretary fraternity in India. Welcome to you, Sudhakar sir. With this, I would like to take it to the panelists to give their initial views on this topic before we go to Sakshi's presentation. Thank you so much.
Bala sir, you're on mute, I think.
Yes.
Yeah, your views, please. Your initial views
Anil,
on
sir?
this topic.
Yeah. Sure. So, just good morning all and welcome to this webinar. As always, we will share the practical insights as well, apart from the law, which everybody mostly knows, but sometimes missed out. So, unlisted company, as we all know, is a company which is naturally not listed on the stock exchange. But if we go a little deeper, because I have done this research about a year back, and as on June 2025, MCA had about 2.9 million registered companies. So which of course includes your public company, private company, LLPs and the likes. And out of that, as we all know, only around 7,000 companies are listed on the stock exchange. So the plethora or the magnitude of unlisted companies is large, and many a times we miss watching the large space occupied by unlisted company, and naturally the compliance is around it. And as we all know, unlisted companies are the companies which are encouraging innovation, helping the country and the state in regional development, helping the professionals also, because we professionals, company secretary or chartered accountant, will not have all the listed company to cater. So it is the unlisted company which majority of them consist are, on our plate. So we should be mindful of their compliances and all that. That was one. And, as we walk through this presentation, we will share more thoughts on this, that on the slide by slide, that what is really required from a practical perspective. Having seen the Satyam acquisition closely, we will deliberate on that as well. So just to before that, I'll just say that SS-1 is the savior for all unlisted company. We have seen in Satyam that it complied the law, it maintained the statutory registers, it had all the documentation very nicely maintained, including the SOPs on its website, and awareness of it in the team, etc. And therefore, that saved the company secretary there. So therefore, our compliance uh, look and by virtue of record also should be finely looked upon. With that, I'll take a pause and over to you, Bala sir.
Over to Sudhakar, please.
Thank you very much, Bala and Anil, and good morning, everyone. Being associated with the Secretarial Standard Board for the past 11 years and working throughout SS-1 as well as SS-2, which could see the daylight. And also, initially, there was a lot of commotion about these standards. I would like to dwell upon the initial phase of these standards and what is the objective of these standards. Also, for the benefit of the participants, I must say that ICSI has instituted this Secretarial Standard Board way back in the year 2000. And that board has came out with about 10 secretarial standards on different topics. Subsequent to the Companies Act 2013, then the new board has been constituted and all the earlier 10 secretarial standards were withdrawn. Most of them have been incorporated in SS-1 as well as SS-2. And what is the objective of SS-1 and SS-2? Initially, there was a lot of criticism was there for these standards, that it is a duplication of Section 118, and already the provisions are there in the Companies Act. Why this additional compliance burden? And you all might be knowing that as a part of SS-1, the maintenance of attendance register is mandatory, and the attendance is to be taken, the roll call is to be taken. So it was felt that the say what's called as the procedural part has been increased than of the policy part. In fact, sometimes when we look back, the governance, apart from the governance, if you see the law also, there are finer, minute points which we forget over a period of time. And these are the ones catch our neck when any kind of governance setbacks takes place, or any kind of family feuds, or any kind of board disparities takes place. Suppose if a director challenges the board meeting, how unless until you have a meticulous board processes, it will be very, very difficult to withstand the scrutiny of the regulators as well as of the courts. In addition to that, if you see the secretarial practices, what company law says is about the legal practice, legalities of the provisions and all what are to be complied with. How about the procedural part? So if we see that in the history of the corporate laws, the big corporate houses has institutionalized certain practices which have been followed over a period of time by the other companies. So the secretarial practices were not standardized. Different companies used to follow different secretarial practices, whether it is drafting the agenda, drafting the notice, drafting the minutes. So with this, the directors were also not having it, especially the independent directors, which are mandatory post Companies Act 2030. They were not knowing that which is the correct practice even. If one company is giving the agenda in one way, another company is giving the agenda in another way. One company is giving a notes on agenda in a very comprehensive manner, other companies were not giving it. So the primary objective of the secretarial standards are to harmonize the practices, integrate and standardize them. What over a period of time, as I mentioned, that different practices will be followed, which have been standardized. At the same point of time, initially there in the Companies Act 2013, a lot of ambiguity was there and a lot of complexities were there. So to a large extent, these ambiguities and complexities have been addressed in the Secretary SS-1. And to a large extent, SS-1 has reduced the propensity of litigation. If you see the good in the Ramaya's commentary in the Companies Act 1956, in the erstwhile 397 and 398 minor that operation and mismanagement cases. There used to be hundreds of pages which have been dedicated for this purpose only. And most of them were unlisted companies. They were having a family feuds, they were having some kind of a family fights or what's called as the board disparities and all these things. So the litigation was more in the good olden days. Post SS-1 to a large extent, the litigation was the propensity of litigation was reduced. How? Because since SS-1 has been made mandatory, you have to ensure that whether we like it or not, we have to comply with those provisions of SS-1. And the moment you follow that, there is no proximity for any kind of litigation. And SS-1, except to one-person companies, is applicable to all the companies, whether it is a private company, public company, unlisted, or a listed company. To every Section 8 companies, to every company, it is applicable. So, standards are in addition and not in substitution of the relevant statutory provisions of the Act. And as I mentioned to you, that initially there was also an issue that why secretarial standard have been made mandatory to private limited companies. Listed companies, one can always understand that they are big companies, their public exposure is there, so they have to do it. Why in case of wife and husband companies, father and son companies, brothers companies, why we have to have this paperwork? In fact, if you may appreciate that the listed companies are always on the radar of the regulators, which are not there is the private limited companies or closely held public companies. The litigation used to be there more in these because these companies, with all due regards to them, they give scant respect to the governance, they give scant respect to the compliance. So to ensure that, in fact, in the good olden days, whenever I used to talk about secretarial standards, I used to give a standard example of wearing the seat belt while you're driving a car. Whether the seat belt you have to wear it when you're driving Maruti 800. In those days, of course, Maruti 800 these days may not be there even. It was a small car, you can say. Maruti 800, or you are driving a Mercedes. For which car you need to wear the seat belt? According to me, considering the vulnerability, the small company, Maruti 800, better to wear the seat belt. Even if you may be able to afford not wearing the seat belt for a Mercedes car because the build of the car itself is so robust, it may be able to withstand the shock of an accident, which may not be so in case of the small car. So according to me, the importance of the governance as well as the compliance is more for the smaller companies than of the larger companies. If you see these days, in fact, Bala sir writes every week one article on this adjudication orders of the ROCs. The ROC is now taking, in fact, in my 40 years of corporate life, I never observed that such minutest of the minutest non-compliance has been viewed in a microfine glass and stringent penal provisions have been imposed upon. A private limited company which has not done its pagination of the minutes book have been penalized that every director is 50,000 rupees and the company is 50,000 rupees, total is about 250,000 rupees for such a non-compliance. So what we need to do is that SME companies, private limited companies, we need to sensitize them the importance of the governance, the importance of the compliance, the importance of availing the professional services. At the same point of time, wherever the practicing company secretaries are holding these companies on retainership basis also, with all due regards, with all due respect to those company secretaries, whenever the company is getting penalized by ROC, I always feel that what my brother company secretaries are doing for these companies. It's not like that those companies are not having it because sometimes the company secretaries were there also. Sometimes when I interact with the PCS, the PCS says, promoter hamari baat sunta nahi hai. And promoter doesn't pay me to do all these things. If our mindset is like that, whether it is correct or not correct, I leave it to you to introspect about that. Similarly, signing the notice, we take it, notice is a very, very fundamental document. In fact, I also must say that in the prior to Companies Act 2013, when I was in Reliance, when I used to interview the company secretaries, that time they used to say that, sir, I'm the company secretary, but I don't need the routine stuff of the company secretary. I do everything and anything other than the secretarial services. But if I ask you that, who can sign the notice? whether an authority is required for that or not. Because when it go for a litigation, I will take another 2-3 minutes more, Bala, because I am so passionately
Please go
attached
ahead.
to SS1. I can't hold myself without talking all these things. If the litigation arises, the first question will come is the notice will be challenged, whether it has been properly drafted, whether all the ingredients which are required, whether they are there or not there, whether the letterhead is properly there or not there, the person who signed the notice, whether he got sufficient authority to do that or not, all these questions will come. Same is the case with minutes. When you're drafting the minutes with all due regards, there are company secretaries who draft the minutes in present tense, go to the past tense, and sometimes go to the future tense also. In Secretarial Standard, if you see that, the minute in indirect we went. The question may arise that the right to inspect the minutes. If you see that,
I think some network issue.
Yes, I think so. This is joining back in a while.
You're on mute, Sudhakar.
now,
We lost.
Yeah,
Yes, yes.
you're perfectly
Uh,
okay. I think
so
you have to narrate
yeah,
something like we
there
missed something.
there was a power breakdown actually because of
Okay.
that. I got disconnected. So when we
Okay.
see the minutes, that whenever the litigation arises, the minutes are the most important document. It depends upon the company secretary how he is drafting the minutes. In fact, I always used to say that several company secretaries say there is nothing we can do something creative. We don't need to do anything creative. If we do what we are expected to do, that one of the most important thing is drafting the minutes. Because at the time of litigation, this is the only document which is to be presented before the courts as a matter of evidence of what transpired in the board meeting, because no one else got access to that. And similarly, if you see the Companies Act, either 1956 or 2013, nowhere it is clearly mentioned that who got the right to inspect the minutes. Unlike AGM, the meeting minutes of the general meeting, the minutes of the board meeting, who got the right to do that is nowhere there. So it has been very clearly given in the Sector Standard 1 who got the right to inspect the minutes. When that particular slide, that Sakshi put it, I will give more emphasis to the inspection of the minutes. As Anil Bhai has mentioned, that SS1 is the savior for both the professionals as well as the practicing or in service, and to the directors. That time I will give more emphasis on that. What are the new provisions which are not there in the Companies Act 2013, but which have been incorporated, which have been initiated in the SS1. In fact, initially some people used to say that SS1 has overridden the Companies Act to that extent. It is not so. SS1 and SS2 are part and parcel of Companies Act 2013. So with this, I give a pause here and then request Bala to take it forward. Thank you.
Good morning to all of you. I have a great pleasure in welcoming you all on my own behalf and as well as on behalf of Vedant. We heard both the panelists. Elaborately, they have actually given us about the importance of SS1, how it is safeguarded, etc. and all this. I will not take much of the time because since she has to run through the presentation and we will have a lot of things to hear from them. Only thing is, I spent almost about more than 20 years in a listed company. Life was very comfortable. There is no issue. I have never ever visited any ROC office, RD office, nothing in my time. But around the age of 67, I took up a job with a private company and unlisted public companies, a group which is consisting about 20 companies actually. I was a company secretary in 2 of the companies and a private company, a parent and subsidiary. I spent almost about 5 years in that company. It is one of the well-known group. I can name it also. It is a Vodafone group. Not a Vodafone Idea, it's a Vodafone PLC. But I must admit, what I could learn in those 5 years' time in these companies were much enormous than what I could have learned in a 20 years service in a private limited, the public limited company, listed company. There are a lot of things here. As Sudhakar puts it very clearly, there are companies which are required to have the company secretaries, but there are some companies which are not required to have the company secretaries. As he mentioned, the ROC orders, most of the orders, if we could actually go through and see it, it's all arising the companies which are not having a company secretary mostly. If you look at the issue, these are all looking like a trivial issue. Trivial issue such as the 120 days gap is not maintained. And again, the draft minutes are not circulated. Agenda item goes without adequate supporting papers, and then non-recording the director's interest. And again, the draft minutes are not circulated in a 15 days time. The final minutes are not circulated, although there is a waiver could be taken, which is not there. Minutes are not entered in time. There are various signing issue, dating issue, paging issue. Even paging is done by pencil, not by indelible ink. All those matters we actually come across. That is one. These are all very, very trivial things. As Sudhakar says very clearly, I don't look after the routine matters, I do something else. This something else is okay. But if you don't look at these matters, ultimately you are putting the companies and the director into the problem. Very severe. That is what it happens actually. That is one. And second thing is what happens is so long as company secretary is not there, it is okay because it is governed by some turnover criteria. The moment turnover crosses, then the question comes immediately. Then you need to have the KMPs appointed. Wherever it is required, the committee requirement, other thing, and all those things is there. But the directors, they are actually concerned with the business. They are not concerned with the compliance. So, only the company secretary take care of the things. Although they are accountable and responsible, it's okay. But as Sudhakar puts it very clearly, it is the practicing professional who are associated. These companies have to caution from time to time. They have to tell them. Law is not saying you the moment you cross the turnover, you have to appoint the person immediately. Law gives you 6 months time. So that means somebody has to actually proactively tell them what is to be done, what is the things, etc. So the things can be set right. That is one thing. Second thing is many companies. If you ask me frankly, I don't know, this group can answer. How many people in those companies, the directors are aware about the SS-1 and SS-2? Have you ever talked about SS-1, SS-2? Have you ever given a copy of SS-1, SS-2? Have you ever brought to the notice of SS-1, SS-2? It's a very small documents. Even a copy can be taken, it can be given to them for going through it. It will greatly help, which I have been doing it actually in these companies when I was there. So this is the thing one has to ensure. But I will not take much of a time. We have a lot of things to learn in this. We have a lot of things to hear from Sudhakar, especially right from the issue of the notice till the conclusion of the meeting, till the preservation of records. Everywhere we have to need a discipline. We need to follow mandatory requirement, failing which we are landing in a bigger problem. That is what I would like to say here. So with this, I'll ask our presenter, Sakshi, to take us through the presentations. We'll move it. Over to Sakshi, please. Yeah, your presentation visible, but you'll have to put it in the presentation mode. Yeah, perfect.
Yeah. Okay.
Perfect.
Good morning, everyone. So we have had a very great introduction about our topic, Secretarial Standard 1, which is on a governing of board meetings of unlisted companies, what we will be going to discuss today quite in detail. Just to begin with, first to understand what is a Secretarial Standard 1. Secretarial Standard 1 lays down mandatory principles for convening and conducting meetings of the board of directors of a company, which covers notice, agendas, quorum, chairman, resolution by circulation, inspection of minutes, making of minutes, and all the details relating to convening of a board meeting. As Sudhakar sir, Anil sir, and Bala sir has explained about the relativity and importance of SS-1, it is very important to understand and really put an emphasis on that it is not anything which is additional, which has been given under secretarial standards. This is only, I would say, a manner of conducting the board meeting is provided under secretarial standards, because our act provides us for sending the notice. It provides us for making the minutes, but how that notice is to be sent, what makes it a valid notice, and how the minutes are to be prepared is nowhere given in the act, wherein our secretarial standards helps us a lot, and a guidance note on that. So Secretarial Standard has been issued by ICSI through its Secretarial Standards Board. But to make it mandatory for all of us, for all the companies and the company secretaries, it has been given mandatory force by Section 118, subsection 10 of Companies Act 2013, wherein it mandates every company to observe applicable secretarial standards for board meeting, and SS-2, which is for general meetings. SS-1 has also issued with the approval of central government, which makes it binding for all the companies, and it does not looks like a best practice guidance for all of us. And as it has been mentioned, it does not override the act. It only supplements, it provides us the guidance how to really follow the act in a better way. Now, to understand the objectives of SS-1, I mean, this question arises a lot of times when we already have an act wherein it all the information and the requirements is being provided, why a separate secretarial standard has been given for the similar thing. So the major objectives comes here as it provides us the uniformity, how the board meetings and the committee meetings are required to be convened. There should be a uniform and uniform practice which needs to be followed by all the companies. It gives a good governance in a way wherein it strengthens the corporate governance by ensuring that the board functions in a proper manner, and it increases the transparency and accountability wherein if the notices are sent properly, the minutes are made in a way it has been written over here, it increases more transparency and accountability within the organization. Also, it protects the interest of the stakeholders, creditors, employees, even the company secretaries working there in the organization with when the information has been sent properly as per the information provided there in the secretarial standards, and it creates a professional benchmark for all of us to understand how to certify the compliances if they are proper or not. Now, to understand the scope and applicability of secretarial standards, we understand that it is applicable to Secretarial Standard 1 is applicable to all the board meetings of the companies incorporated under Companies Act 2013. It is similarly applicable to the mandatory committees of the boards, which are our major committees, are Audit Committee, NRC Committee, SRC, and CSR committees. However, there are certain exceptions to the applicability of secretarial standards wherein it does not apply to one-person company. Section 8 companies, though there is an exemption to the same if this exemption will be applicable on the Section 8 company from following the secretarial standards only if the company has not defaulted in filing of their financial statements or annual return with the ROC. In case the company has been in default, they are required to follow these secretarial standards. Also, these secretarial standards does not apply to limited liability partnerships.
But just one line I have to add here is that Secretarial Standard 1 is applicable to those committees which are constituted under the Companies Act, that is the statutory committees. Why it is? Because if you see SS-1 is confined only to the provisions of Companies Act, it is not extended to the listing regulations. The reason for that was that whenever you prepare a standard, it is to be approved by the concerned regulators. One document getting approved by two regulators is extremely, if not impossible, it is highly difficult. That's why it should took a decision at that point of time that SS-1, we will talk about as far as standard is concerned, we'll talk about the provisions of Companies Act only. But if you see the guidance note, in the guidance note, we are elaborately covered even the listing provisions also, listing regulations related provisions also. So strictly speaking, SS-1 is not applicable to risk management committee, but only for other four committees only it is applicable. That doesn't mean we will comply with SS-1 only for the four committees and not the fifth one. Yes, such.
So there are certain key definitions which has been provided under secretarial standards as well. We will not go through them in detail because it is quite self-explanatory. However, out of those, the important one is electronic mode, wherein it is to be emphasized that electronic mode sometimes is being considered with the audio as well. However, it has been clearly mentioned that meetings through video conferencing or other audio visual means enabling concurrent direct participation without an intermediary. So electronic mode, any meeting with any person who is attending any meeting through electronic mode would be considered valid only if there is a video conferencing mode available. Only audio would not be considered as an electronic mode for that. Similarly, there is one concept of timestamp, which is also very important to understand. Like timestamp is the recorded time of an event on a secured computer system tracks when the data is added, sent, or received. So, if we are maintaining any records electronically, any information is being received or sent to someone, if there is a time stamping, so it has to be a proper time, which cannot be altered eventually. And with respect to the national holidays, it has been clearly defined that Republic Day, Independence Day, that is 26th January and 15th August, along with Gandhi Jayanti on 22nd October, is considered as a national holiday, since certain meetings like adjourned board meeting and general meeting cannot be conducted on a national holiday. So sometimes Gandhi Jayanti 2nd October is missed out of that list. So that needs to be really taken care of and is explained here well.
So, Sakshi, just to add this timestamp requirement,
Yes, sir.
it's not so elaborately mentioned in the Companies Act, but it is finally covered in the Secretarial Standard. So, and later on, now we have this also in the audit trail and so many other things for listed company. It is coming, HDD, etc. So it definitely has an importance, and many a times when the XBRL, for example, for listed company we file, we have to put the time of the meeting starting, ending, etc. So it's an important thing. Thanks for covering that.
Not only that, even though SS-1 is there, but our institute has done a very, very excellent job in bringing out a guidance note. A guidance note is written well drafted, elaborately, giving the illustrative example of many things which one has to go through to understand the things. Because I must say, the guidance note, whatever is brought by the institute, not only this, is excellent. It is the expert mind applications, and one has to make use of it. Unfortunately, when I talk to many people, some of them are not even aware there is a guidance notice available. That is a sad part of it, because we are being a professional. I think we should make use of this, which are there actually. Yeah.
So now we will be discussing on the major points of secretarial standards, which starts with convening a meeting. So a board meeting can be convened in a way that any director can summon for a meeting at any time, and the company secretary of that company convenes it in the consultation with the chairperson or MD or whole-time director as per the presence. In case the company does not have any company secretary, then any authorized person who has been authorized by the board of directors would be doing the would be convening the meeting in consultation with the chairperson, MD, or whole-time director of that board. Meeting can be convened at any time, place, and on any day. Every meeting needs to carry a serial number, which has been mandated. Only that board meeting can also be conducted even on a public holiday. However, the adjourned board meeting cannot be conducted on the national holiday. Meeting can be convened through an electronic mode as well. Any director can participate via video conferencing, unless any restricted item is being discussed in that board meeting. If any restricted item which needs physical quorum, then the meeting's electronic mode facility would not be available therein. If the meeting is conducted through electronic mode, the recording is mandatory, and the recording is required to be preserved as well. And no unauthorized person can have the access of the proceedings of the recordings of the meeting. In case the company is conducting a meeting through a VC, then the proper facility is also required to be provided, and it has to be written in the notice itself, the manner of attending the board meeting through that electronic mode, and all the systems, which is hardware, software, anything required should be provided to the directors. And in the minutes as well, it has to be specifically mentioned which director has attended the meeting through the electronic mode. And there is also one compliance which is added if the meeting is conducted through electronic mode. One is the roll call. Any director who is attending a meeting through a VC needs to confirm their name, the place from which they are attending that board meeting, confirmation to the fact that they are alone in that room. I mean, no other person, unauthorized person, has the access to the proceedings of that meeting, and they had received all the agenda papers in advance. Also, when the meeting is conducted through an electronic mode, the summary of decisions of needs to be announced at the end of that particular board meeting.
So,
Sagar, I would like to hear from you on this more on the video conducting. Question.
Yeah.
Whether company only can provide the video conferencing or any director can demand a video conference.
See, before that, Bala, I would like to talk about the authority to summon the meeting. Under the provisions of Companies Act, any director can ask the company secretary to summon the board meeting because he has certain issues to take up. The company secretary at that point of time rightly mentioned in the SS-1 that he has to consult the chairman in the absence of chairman, MD or whole-time director, and then he has to convene the meeting. The question may come that suppose if the chairman says, no, don't convene the meeting, then what is the role of the company secretary then? He cannot simply, like a postman, he cannot tell the director, sir, chairman said, no, don't convene the meeting. He has to first of all refer to the articles of association. What sort of provision have been made, if at all, in that whenever a director asks him to convene a meeting, whether he is duty bound to convene? If it is so, even if the chairman says no, he may have to issue the notice. Similarly, at the same point of time, when he is taking that requisition of the director to the chairman, it is a responsibility of the company secretary to brief the chairman that what sort of authority that concerned director is having it. Even if the company secretary is not issuing a notice, the director concerned himself can convene the meeting also. Whether the meeting will be held, whether the directors will attend or not, that is all different thing. But he can issue the notice at that particular point of time. So the legal provisions the company secretary should be in sync with, and he has to apprise the chairman about that. Whenever a director requests to convene the meeting, governance point of view also, the company secretary has to make the efforts, convince the chairman concerned before convening the meeting. Now come to the know about this. There is no requirement for any physical quorum for any purpose. If you see Secretarial Standard, still it is there that for the restricted items you require physical quorum because SS-4 that Secretarial Standard 1 and 2, they are to be approved by the Ministry of Corporate Affairs. Any kind of comma, full stop change also, we have to go back to the ministry. So, when Companies Amendment Act 2015 has come, those provisions have been incorporated and the SS-1 was revised in the year 2017. Then Companies Amendment Act 2017 has come. We have again suitably, we have revised that, given to the ministry. It took long time. Meantime, COVID has come. And then that ministry has approved it ultimately somewhere in the year, I think, if I am not wrong, 2023 or 24. And then only that revised standard could come in 24. But by that time, this amendment relating to the requirement of the physical quorum for restricted items was not there. If we want to change that again, it will go into a loop. That's why what we did was we have not made that amendment. And whatever the approval has come from the ministry, it has been the SS-1 to that extent it is revised. And in the guidance note, the same has been elaborately explained. Now the question of video, so that means what all the directors as on date can attend the board meetings in a video, in a virtual mode. As Sakshi has mentioned, affirmations have to be given as required under the rules. And unfortunately that most of the times I have observed that whether it is official meetings, on team calls and all, executive meetings or board meetings, people don't switch on their cameras. So it is the responsibility of the company secretary to insist upon the director concerned to switch on his camera at least while giving the affirmation, if not anytime else. At the same point of time, whenever a director participates in the meeting, that means he is making a statement or he is putting some questions or something like that, he has to switch on the camera, if not throughout the meeting at least. So that meeting protocols have been strictly to be laid down. And to the extent possible, everyone has to switch on their cameras. Now the question comes that the video recording is to be maintained how long? It is mentioned clearly in the rules itself that video recording is to be maintained till the next audit takes place. Now the question comes, who can ask for a copy of the recording? Can any director ask for a copy of the recording? So as per the prevailing statutory provisions, no director has the right to ask for a copy of the video recording. At the same point of time, can he inspect the video recording? Yes. In case anyone wants to see that, yes, a director, you can show the video recording to him, maybe on his laptop or maybe in a conference room or whatever it may be. So the question comes that can the director audio record the meeting on his mobile or on a suppose on a recording machine or whatever it is? Again, the answer is no. In fact, why I'm saying this thing so authentically is when I was in Reliance, in one of the JV companies, one director, a JV partner's representative, he said that I need a video copy of the recording. Then we examined the provisions, we examined the legalities and all those things, and we have simply politely replied to him that no, we will not be in a position to give the copy of the recording. And let me also take this opportunity. Several company secretaries, without understanding the sanctity of the minutes, they give certified copy of the full minutes even to the auditors. Not required. You have to give only extracts of the minutes of the meeting, like resolutions. Maybe some auditor may say, look, for my peer review audit, I need the copy of the resolution. You can give the extracts only. No, don't give the full copy of the minutes to anybody. Similarly, video recording is not to be given the copy of that. No director has the authority to audio record the minutes also. Now the question comes, can the company record the minutes? I mean, record the proceedings of the board meeting? Yes, a company secretary with the permission of the directors can record the audio record wherever it is. Suppose if the video recording is not there, then all the directors are physically present. That point of time, to ensure that all the points are captured properly in the minutes, he may opt for the audio recording, but again, the same thing, he has to take the permission of all the directors there.
So just one point on this electronic mode. Many times awareness is not there amongst the, our own company secretary folks as well as directors sometimes, that this electronic mode of meetings, when they are there, sometimes they do audio recording. And in such cases, the director concerned, if he has attended through, electronic mode, he will be treated as absent for that matter if video recording is not done and only audio is done. And sometimes the directors have lost their commission for that meeting as well, if there is a sitting fees or commission calculation. That is one. Two is that in this electronic mode, like, there has to be some training or awareness also to be made for the directors concerned, that they cannot talk like a regular meeting, anything and everything. Sometimes, loose talks are also there, and those gets recorded in the electronic video recording. That is two. Three is, since the pandemic, electronic mode or video recording has become more prominent. And due to this, what has happened, the recording is there for a big length. And unfortunately, what happens is the minutes which our professionals make or our company secretaries make or the juniors make, those are very elongated one. That's not the it is not that everything what is said has to be recorded in the minutes, and it has to be precise to the point. Of course, whatever the directors or the KMPs have said or the invitees have said, and if it is pertinent, one should cover it in the minutes, but that doesn't mean that the minutes should be too long. I thought I'll just cover this.
So, to continue with that, the chairman may adjourn the meeting at any stage if the majority of directors are not, unless the majority of directors present object that. Otherwise, chairman has the right for the adjournment, and the adjourned meeting would be held next week, same day, same place, same time. But if it is a national holiday, it would be conducted the next day of that, which is a non-national holiday. Now, we discuss about the notice of the meeting. For convening a board meeting, a notice is a very important and the first document that needs to be shared with the directors. So, minimum 7 days written notice before the meetings is required to be sent to all the directors, unless the articles prescribe longer. If the articles prescribe a longer time, the company is required to adhere to that timeline. Plus, if 2 days extra would be added if the meetings is if the notice is sent by speed post or the registered post. In case the notice is sent by hand, speed post, registered post, or any manner, any electronic means as well, it needs to be sent to the director's registered address or the address which has been given by the directors in their den. Sometimes it has happened that the company gives fix the calendars of the meetings for the whole year. I mean, so they decide like they'll be conducting 6 meetings and the dates are already been decided for those meetings. Still, in that situation, a proper notice for each and every meeting is required to be given. It's not like you have discussed this well in advance and the calendars has been blocked. So the requirement of sending the notice is not mandatory. It is still mandatory. The notice needs to be sent to all the directors. Proof of dispatch and the delivery of the notice is required to be preserved for more than 3 years from the meeting date. Notice should also clearly set out the necessary information, which if the meeting is conducted through an OAVM mode, then the manner of participation, the link, details of software and hardware, if any other further infrastructure is required from the director's side, that all needs to be mentioned in the notice very clearly, and the details of the person, either the company secretary or the person authorized by the board of directors, their contact details needs to be mentioned so the directors can reach out to them in case of any problem. As we've discussed, the minimum 7 days notice or any other date which has been prescribed in articles needs to be there. However, notice can be sent at a shorter notice as well. Meeting can be conducted, but it has been mentioned very clearly that any urgent business can be taken up at a shorter notice if one independent director is present. However, for the private limited companies, there is no requirement of having an independent directors. So for the public companies wherein the independent director is required with the limits has been prescribed under the Act. So then the requirement of independent director is there. Otherwise, the majority of the directors would be there. But it has been clearly mentioned that only in the case of an urgent business, the notice would be can be sent on a shorter notice. It cannot be an each and every agenda item cannot be sent on a shorter notice. Each and every board meeting cannot be conducted on a shorter notice. If the meeting is conducted at a shorter notice, the fact of the same is required to be mentioned in the notice itself that the notice is sent on a shorter notice. Also, if there are any UPSI agenda, unpublished price sensitive information agendas, is part of the notice that can be given at a shorter notice. However, the consent of the majority of the directors is required to be taken from the board itself. If they agree, then the UPSI agendas can be sent at a shorter notice. And if the meeting is requisitioned by the directors, then it is advisable in the Secretarial Standard to mention in the notice itself that the meeting is convened on the requisition of any director.
Yeah, just to add one point to this, that a director is having a right, statutory right to attend the meeting in a virtual mode. He can always ask the company that I want to attend the meeting in a virtual mode, and the company is obligated to arrange that video conference. And similarly, you have to also give the option to the director concerned in the notice. You have to clearly mention that any director would like to join the meeting in a virtual mode, they have to they have to contact the company secretary, and so that the necessary arrangements can be made. Of course, he can say that 2 days before or 1 day before you have to do it. In the good olden days, organizing a video conference was a big job, whereas these days it is just a Zoom link only. So even if it is at 2-3 hours before, also he gives, that is also fine. 1 day notice should be sufficient enough. So, but one thing, please remember that in the notice, you have to clearly give that option to the concerned director. If it is not there, it may lead to a non-compliance. And once the director asks that point of time, there was a question also I have seen that if only one director out of the 14 directors are attending the meeting in a virtual mode, is the recording mandatory? Yes, the recording is mandatory at that point of time. Yeah.
Whenever you conduct such a meeting, normally the notice is issued most probably from register office or even any other place also. But when the meeting is actually called for the physical meeting and somebody joins in the video meeting, it is not the video conferencing. It is still a physical meeting, but particular director join as a video. So the venue of the meeting is actually the place from where the notice is issued, where the meeting is conducted. Recording should go appropriately. This particular person is attended through the video conference. While drafting the minutes, I think she is coming to that. So this care has to be taken care. Yeah.
So talking about the shorter notice, what we have observed when we came to the other side of the profession, in listed companies, of course, there is not much of shorter notice usually given on and off. But in the unlisted company space, invariably, lot of meetings happen at shorter notice, and that we as professionals should guide the management and the concerned company secretary that this should be avoided unless there is life and death. That is one. Two is that nowadays many venture capitalists and investors are also investing in unlisted company when they see some future in the management or in the product or services of the company, and eventually these companies go for listing as well in a period of 2 to 4 years. So at that point of time, the proxy advisors or the analyst, they may look into this data also one way or the other, that how's the culture of the company. So as a discipline, we as professional should highlight this to the management of the respective unlisted company that this should be avoided. That is one. Two is also, when we'll talk of the agenda, of course we can talk there. Many a times it so happens that the normal 4 5 items of the board meeting agenda is given, and then you have a laundry list of other business which is conducted, and even the notes to agendas are sent at a just a day before or sometimes even on the day of the meeting. So such practices also should be brought to the attention of the management, that this cannot be there unless there is something like acquisition, etc. One can understand, but the other businesses, they should be included in the agenda, and with, of course, comprehensive notes there too. That was a limited point.
Anil, thank you. You well touched upon this point actually. Because what happens is many times the 7 days notice, why it is actually required. The 7 days notice is required because to give the details of the meeting and the supporting document to the director to go through, so that they well prepared, they come for the discussion and deliberation, so that a proper decision in the interest of the all is actually taken. That is the whole purpose. As you rightly say, if everything is scheduled with the permission of the chair in the item and everything is tabled on the last minute at the board meeting itself, there is no discussion deliberation. That is what it happened. That is the purpose where it is actually defeated, number one. Number two, what happened? The question comes in some of the unlisted companies where they require to have the independent directors. I will not get into the question whether the independent director really independent or otherwise another thing and that. When you talked about the shorter notice, it is understood. We have some directors who are, we are uncomfortable. So deliberately we want to avoid. So shorter notice, they are not able to attend the meeting. As you rightly say, that should not be the case. The shorter notice is a provision which is given by the law. Only conduct emergencies, exigencies meeting, which could not be visualized for the particular board meeting. The item which can wait till the next board meeting, it should be taken in the regular board meeting, unless until some business necessities, exigencies there, then only we should actually go for the shorter notice.
Yeah, thanks, Bala.
Thank you, sir. So just to add on to the point that in case the whole meeting is conducted through the video conferencing, like everybody is attending the meeting through VC mode from a different locations, the deemed location of conducting the meeting would be the registered office of the company from where the notice has been sent. So similarly, there has been, as we have discussed at the start of the presentation, the importance or the objectives of the secretarial standards. So the Act provides us for sending the notice 7 days in advance, but it does not say a lot about what needs to be there in the notice to make it a regular notice or a valid notice. So secretarial standards has explained this very well in a way that notice, what is the form of a notice which makes it a good notice or a valid notice, in a way that it needs to be sent on the letterhead of the company. However, in a situation wherever the notice has been sent through an email or any other electronic means, it should be very clearly specified as the header or footer. However, the name of the company, the complete address of the registered office of the company, along with the particulars of the SIN number of the company, as same is required under Section 12 of the Act. Date of the notice, the authority and name and designation of the person who is issuing the notice should be clearly mentioned, and phone number of the company secretary or any other director who has been authorized by the board to issue the notice should be mentioned in the notice. Uh, so uh, this is the requirements which has been mentioned, that which makes a notice a valid notice. In case any material irregularity is found in a notice, I mean, if the notice is not sent properly on without the SIN address, SIN number, or the details of the person who is being issuing the notice has not been mentioned, it makes the notice as a defective or an irregular notice, which eventually affects the validity of the meeting itself and the decisions taken thereat. So it is very important to understand, in case the notice becomes defective, that the meeting which has happened after that notice would be questioned. The validity of that meetings would be questioned, and all the decisions made at that particular meeting would not be valid in a way. And in case, if we talk about the form of the notice and the defective notice as well, however, in the situation where the notice is sent properly, however, it has not been sent to all the directors, then also it becomes defective notice. So notice is required to be sent to all the directors. If it is not being sent to all the directors, the resolutions passed at that meetings are not valid. Now the question arises, the second question, like who can sign the notice? So in wherever there is a company secretary in an organization, the company secretary should sign that notice. However, in the private limited companies, as we have discussed, if they are below that threshold of appointing a full-time company secretary, then in that situation, notice should be signed by any other director or any other person who has been authorized by the board of directors to issue the notice. Now, there have been certain case laws with respect to the notice of the board meetings. So there is a case of Parmeshwari Prasad Gupta versus Union of India, wherein the Supreme Court held that the board meeting convened without a notice to a director is fundamentally invalid, which we had discussed already, that notice, if not sent to all the directors, is also a defective notice. So in that particular case, same situation happened, where every director's statutory right to notice is real, and it is not a formality that can be dispensed with informally. So accordingly, since the notice was not sent to all the directors, the decisions taken at such meetings were not binding on the company. Similarly, in another case which has happened with the Shelja Krishna versus Satori Global Limited, so a shareholder director was removed from the management through the board meetings, for which that particular shareholder directors were not served the notice, and company could not produce any proof of dispatch of the notice to that particular director. So NCLT set aside the resolution of removing that particular shareholder director. However, NCLAT somehow reversed that jurisdiction on the technicality grounds. But on the appeal, the Supreme Court restored NCLT's findings, holding that the fraud and procedural manipulation of board meetings squarely fall within the tribunal's operation and mismanagement jurisdiction. It is a mandatory requirement to serve the notice to all the directors of the company. Otherwise, the notice would be defective, and Secretarial Standards clearly defines that in that situation, the decisions taken at that board meeting would not be binding of the company and they would not be valid. So this particular thing has been clearly defined from these two cases. Now we'll come to the next topic, which is agendas and notes on agendas, which is also shared with the directors along with the notice. So we know that there is a 7-day rule for the agendas and the notes and the notes to on agendas as well, that needs to be sent 7 days in advance before the meeting. Similar to the notice, in case the article provides a longer time period, that needs to be adhered to by the company. And if the particular agenda is sent through the post, 2 days to be added to that 7 days requirement. So now each So there is a serial numbering which has been mentioned at quite a lot of times in this secretarial standards, wherein if the meeting is conducted by the of any board or committees, they should be serially numbered, which meeting of that board meeting number, and the agenda items as well in the board meeting should be serially numbered so that it can be easily referred to, and in the minutes as well. Similarly, those numbers can be referred to. Uh, Also, with that respect, the order of discussing the business at the meeting should also be in that manner, in which the agenda has been sent to the directors. However, if there is any change, if any directors or the company secretary wants to discuss certain other agendas item before or after, that needs to be permitted by the chairperson to do so. All the agenda items that requires approval, they should have a proper supporting documents, a proper proposal details, the material facts, and if there is any director's interest or the KMP's interest in that particular agenda item, that needs to be clearly mentioned in that particular agenda supporting notes. Also, if the resolution needs to be passed in that particular agenda to be discussed, the draft of the resolution needs to be sent through that agenda item itself to the board of directors. However, it can be modified while discussing at the meeting. There are certain agenda items which are not being sent in advance to the board members along with the complete set of the agenda. However, that can be taken up as an additional agenda if the chairman of the board permits for the same and the majority of the directors agrees. Then that additional agenda can be taken, and the majority of the directors needs to ratify the same, and it has to be approved by them. And the supplement.
In fact, this serial numbering of the meeting and all, that is the most important thing which is there at SS-1, which is not there in the Provisions of Companies Act. In fact, the tampering of the board minutes used to be rampant, especially in unlisted companies. And with that, several times it happened that the company secretaries, despite the fact they left the job years before, but still sometimes they used to get summons from the court to come as a witness for the years of the where he or she was working as a company secretary, because some minutes were inserted in that. So now with this serial numbering, those issues are to a large extent has been arrested. Those issues are not going to be there. The reason being, even in the notice of the board meeting also, you have to mention the number of the board meeting for which that notice is being issued. Suppose if that minutes or somebody is trying to insert in that, they cannot change the notice because the notice has been signed by the concerned company secretary at that point of time. So this has put some companies into difficulties also, but it is a real good governance measure of serial numbering the board meeting.
Okay, so there are the illustrative agendas list which has been provided under secretarial standards for to be conducted in the first board meeting. These agendas to be required to be taken in the first board meeting. However, the major and the most important agenda comes in wherein it considers the appointment of the first auditors, because the first board meeting of any company is required to be held within 30 days from its incorporation, and all the procedural things like the chairman needs to be appointed, the certificate of incorporation needs to be given, any first directors needs to be noted, that can be done. However, the company needs a bank account to be opened. So all these things are done in a procedural manner. However, the most missed agenda, or the agenda wherein the companies kind of fail to do so or fail to do that within the due timelines, is the appointment of the first auditor, which needs to be done within 30 days from the incorporation of the company. Similarly, this has been discussed in a case law of Dhando India Private Limited, wherein the first board meeting of the company was held beyond 30-day limit. The company was incorporated on 18th May 2015, but it held its first board meeting only on 17th September 2015, which was well past mandatory 30-day window under section 173 subsection 1. So, and the company has mentioned that the delay was attributed to non-availability of the directors and companies or the compounding. However, NCLT Mumbai imposed a penalty and a 25,000 fine on the company and each of its two directors for not conducting the meeting within the 30 days of its incorporation. So, to come up on a next topic, which is the frequency of the meetings. We all know that the board meetings, a company is required to conduct minimum 4 board meetings in a year, and the maximum gap between those two consecutive board meetings would be 120 days. And as we have discussed, the first board meeting needs to be held within 30 days after the incorporation. There are certain exemptions to the fact that the one-person company, small company, or a dormant company, or a private company which has been recognized as a startup can hold one meeting per half calendar year, a gap of not less than 90 days between the two meetings. So the major important point which needs to be discussed herein is, like, we all know that the 4 board meetings needs to be conducted, but that does not, along with that, 120 days is the maximum time gap. If there is a gap of 121 days as well, it is a non-compliance and that needs to be adhered to. Along with that, one meeting needs to be held in each calendar quarter. It's not like, we kind of count 120 days and we can miss somehow one calendar quarter. That is also a non-compliance to the fact. So along with the 4 meetings, minimum 4 meetings and 120 days gap, we need to really adhere to the calendar quarter as well. For the committees, they can meet as whatever has been mentioned in the act, or the board decides for their frequency. So that needs to be adhered to for the frequency of the committee meetings. And with respect to the independent directors, as it has been mentioned, they must hold at least one meeting per financial year without the presence of any non-independent directors or the management to review the performance of the board and the chairperson. And it also is required to check the timelines of the flow of information in the organization. Now to come to the next very important topic, which has been given quite in detail in the Secretarial Standard, is the quorum requirements. To make any meeting valid, the quorum is required to be there. I mean,
Saksha, it is 12:15 and you are in quorum, so you have to gallop now. Okay.
Yes, sir. I'll be fast. Yeah. So the quorum is quorum makes any meeting as a valid meeting or not, because if there is no presence of quorum, the meeting would be considered as invalid or adjourned at that moment without the presence of the quorum. So it has been given in the act what is the requirements of the quorum is 1/3 of the total strength or 2 directors, whichever is higher, and the fractions are always rounded up. But the major important part for the quorum is that the quorum is required to be present throughout the meeting, not at the commencement or the end. It needs to be throughout the meeting. If any directors are interested, they need to be, for any particular agenda item or the whole of the meeting, they need to be excluded from the part of the quorum for that particular item. However, there is an exemption which has been provided to the private limited companies. If the directors reckon they need to disclose their interest, and then they can be part of the quorum since they have the less of the directors in the private limited companies. If any person is joining a meeting through video conferencing mode, that would be considered for the quorum. We have already discussed that quite in detail. And as it has been mentioned, if the article provides more quorum, more than 1/3, then that needs to be adhered to by the company. If the company fails to adhere to the same, the meeting will be held adjourned. So now,
Sakshi, when you touched upon the quorum,
yes, sir.
as Sudhakar was telling, always we need to check the articles of the company. In some of the companies, if they have the foreign collaboration, joint venture, etc., and other things and all, what happens is there is always a requirement whenever you conduct the board meeting, the director of that particular parent company need to be present. Without him, the quorum is invalid. These sort of the clauses will be there in the articles. So although you may have about 7-8 directors, 1/3 you calculate 4 people are there, but unfortunately the particular director whose presence was mentioned in the article is absent. Still it is not the quorum.
Yes.
Because this, I'm telling from the practical experience, because I was working in the company which was an unlisted public company which went to public later. Initially, when we are going through the listing requirement, we found the quorum requirement was actually containing this, one of the director. The moment we go for listing, then what happens is, as you know, the listing agreement calls every quarterly results to be published within 1 month from the end of the quarter. If that particular director is unable to attend the meeting, then we become a non-compliance. So necessarily, before we start anything, we'll have to get the article amended to such an extent that this does not stand, as sort of a things hurdle for the listing requirement compliance. So that is what we have done actually. So when you talk about the quorum, one has to be very well versed with what is the requirement of the article. Accordingly, one has to ensure that to ensure the quorum is available.
So, in case the quorum fails, we have already discussed that if the meeting is not can be held because of the failure of the quorum, the meeting stands adjourned, and adjourned meeting would be held on the next week, same day, same place, unless that is a national holiday. If that is the case, then the next non-holiday day would be, and same day, same time and place would be the time of the adjourned board meeting. However, if there is no quorum at the adjourned meeting as well, then the meeting stands cancelled. So now, with respect to the interested director, the quorum fails because of the interested directors are more than 2/3 of the total strength. So the minimum 2 directors would form the quorum for that particular agenda item. In case the directors are who can form the quorum, as mentioned in the articles, then the business cannot be conducted through except to raise the number. Either they have to raise the number of the directors or they call a general meeting to really transact that particular agenda item. Also, there is one point that needs to be mentioned, that the proxies cannot be appointed in the board meeting for the part of the quorum.
So one important point on the quorum, Sachi, of disinterested directors. Sometimes when there is a RPT approval in the meeting,
Yes.
obviously the interested director would not be forming the quorum. So and for that matter, 188 is applicable to all the companies. It is not only for public company, it is for even for private companies. So those care has to be taken by the company secretary or professionals that there is an induction of director or the director's required quorum for the meeting is present.
And one more
now-
important point here is, that 1 minute, Sakshi, that if you see the Companies Act, they mentioned that the quorum required to be present. Whether it is required throughout the meeting, Companies Act is silent about that. There is an ambiguity there. So that's why in SS-1, it is mentioned very clearly that you require the quorum throughout the meeting. Especially in case of the meetings which are being held in a virtual mode, it is the responsibility of the company secretary to keep a tab on that all the directors are present throughout the meeting. If at all, suppose somebody got disconnected and that quorum is not there at that particular point of time, till the time he rejoins the meeting, the meeting should not be proceeded ahead because quorum is not there. Suppose for whatever the reasons it is, God forbid, if that director is not able to join the meeting, then you have to adjourn that meeting. Now, suppose in the adjourned meeting also the quorum is not there, the meeting will be cancelled, something like that Sakshi has mentioned. But in this particular case, the decisions which were already taken till such time the quorum was present, they will be valid decisions, and thereafter the board is not supposed to proceed with as far as the agenda is concerned. They may have to reconvene a new meeting unless in the adjourned meeting the sufficient quorum is there.
So the next topic comes as the attendance register and the providing of the leave of absence. As sir has already mentioned, that it is a very important document, needs to be maintained by the company. So the company is required to maintain attendance registered for both the board and the committee meetings, wherein the pages should be serially numbered. If they are maintaining it in a loose leaf form, they can bind it in at least once in 3 years. And the separate attendance registered for the board and the committee meetings needs to be maintained. As we have discussed on the contents, serial number, the date, committee name for the committee meetings, place, time, names, and the signature of the directors, company secretary, and the invitees as well needs to be mentioned in the attendance register, along with the mode of their presence. In case the directors are attending, or the invitees for that matter, are attending through electronic mode, that needs to be clearly mentioned in front of their names that they have attended through VC. Attendance register needs to be kept at the registered office of the company, or if any other place which has been approved by the board of directors to keep the custody of the attendance register, and it should be in the custody of the company secretary. Those registered can be opened for the inspection by the directors, but they cannot, no member of the company can inspect the attendance registers. These attendance registered can be preserved for at least 8 financial years from the last date of entry, and may be destroyed thereafter, but with the board's approval only. And with respect to the leave of absence, any director can take leave of absence from that particular board meeting or the committee meeting, but that needs to be communicated well in advance. However, there is one catch wherein, like, if any director who is not present for the board meetings for 12 months, that the position stands vacated, and the director is no longer a director in a company post 12 months. However, that there is a very clearly illustration provided in the guidance note with respect to the same. If any director has attended a meeting conducted in January, after that the director has not come for any meeting in the particular company for a year. So since when we will count his non-availability, 12 months time period for his absence? So the next meeting wherein he was present, after that, whatever the next meeting is held in the company, since that day, his absence would be counted for the next 12 months, and accordingly it will be noted if the position is vacated or not.
So in practical thing, whenever a company is having meeting other than the registered office, sometimes the meetings at overseas location or different geography of the country, or internationally as well. And many a times company secretary is not part of those meetings. And in such scenario, the attendance register is either carried by the CFO or the likes. So in such instances, many times they forget to take the signature of those directors. So company secretaries have to be very mindful that all this is, handled, because at the end of the year when there is secretarial audit, if it is applicable, or statutory audit also, all this will come into play, and the concerned CS may be in trouble.
Now the next topic comes as the
and one more, Sakshi, one more important point is that, as Sakshi has mentioned, the invitees also have to sign the attendance register. Especially similarly in the minutes of the meetings, also board meeting or committee meetings, you have to mention the presence of the invitees. After the board of directors in attendance, then you have to have invitees column. There you have to mention all the other people as invitees. So there, if any invitee is there only for a particular agenda item, then you have to mention clearly in the brackets that he was present only for that particular agenda item. So as a PCS, or in case you are attending any board meeting for a particular agenda item, please ensure that you are signing the attendance register only for that item, not for the remaining that board meeting. Because this is very important in case of any litigation arises out of that board meeting, for all the people attended that board meeting, and what they may be also make particular litigation. The same point of time, any kind of unpublished price sensitive information leakage or something like that happen, that unless your right is clearly mentioned, will be a part and parcel of that particular litigation.
Now the next topic comes as the role of the chairman. So a company chairman is a person who chairs the board meetings. Generally what happens if a company decides one director as the chairman of the board. However, if there is none which has been decided well in advance, the directors elect one of them amongst themselves as the chairperson for that particular board meeting. The chairman always required to verify with the company secretary, if there is a company secretary available, that the meeting is duly convened and constituted before the business begins, so that it is a valid meeting. It needs to be confirmed by the chairperson. In any agenda item, if there is a conflict of interest, if the chairperson himself is a interested person, then he has to vacate that position for that particular agenda item, and the non-interested director becomes the chairman for that particular agenda item. And the chairman who was interested he cannot be present physically or electronically for discussing that particular agenda item wherein he is interested. So it is the requirement, as we have discussed a lot on the electronic meeting conducted through VC, that they are required to ensure security of, identification, and the security needs to be done, that the directors who are concerned can only have the access to the proceedings of the meetings. And in case there is a tie, then the casting vote is provided to the chairperson. But however, the same needs to be verified from the articles. Now, the next topic comes as the resolution by circulation that can be the resolutions which can be passed by the circulation, before that which proper meeting cannot be required to be held by the directors. Very important part for the resolution by circulation is that it is considered the resolution which has been passed by the majority of the directors through circulation will be considered valid, as if they have been passed at a duly convened board meeting. And chairperson or the MD or a non-interested director, their absence, decide whether a matter can go by a circulation before or not, before the draft is sent to all the directors. So the draft resolution along with all the papers is sent to all the directors, including the interested directors, in any way, by hand, post, courier, or email, similar to the notice of the board meeting. So, and the response time is given as a 7 days to all the directors to respond with their assent, dissent, or abstainment from the particular resolution. And 2 days is added if the courier mode has been chosen. If more than 1/3 of the directors wants that particular agenda item which has been sent to be passed through circulation needs to be decided at the meeting itself, then it is the chairman's responsibility that agenda item is discussed at the duly convened board meeting rather than a circulation. However, the directors who has received the draft resolution can approve the resolution by circulation, and who are entitled to vote on that. Any interested director, they cannot vote, and if there has been no response from the directors, either they say approve or they can say reject as well. However, if there is no response from any director, that would be presumed as they have abstained from voting on that particular resolution. And same needs to be clearly minutized in a way that wherever there is a next board meeting convened, that any resolutions passed by circulation needs to be really put into the minutes of the next board meeting, wherein the date of passing of the resolution is to be mentioned. And if any directors who has dissented for that particular resolution needs to be clearly mentioned, and the directors who have abstained themselves from from voting on that resolution, that also needs to be mentioned. And if any directors was interested, all these information along with the passed resolution needs to be properly minutized in the next board meeting. However, there is also one point we have noticed during the practical aspects is the date. There are certain different dates during the resolution by circulation. Like one date is the circulation of the resolution to the directors. The other date is the 7 days window date. But the third date comes the past resolution when the resolution is considered as passed. So it is not the circulation date. It is not the 7th day. It is the date wherein the majority of the directors passes a resolution. They give the approval. The day on which the majority comes for the approval, that would be considered as the passing date of that resolution. However, the effective date, if it is mentioned otherwise in the resolution that this particular resolution would be effective from so and so date, would be considered. Now, there are particular list which has been provided in the Secretarial Standards, even in the Act, what agenda items that cannot be passed by circulation that company needs to adhere to. If any agenda item that company is still passing through circulation mentioned in the list, that particular resolution would not be valid. And if there is any appointment or the removal would be done through circulation and it is not allowed, then that would be void. void.
Touching one point on the circular resolution.
Yes,
Many a times the resolution, as you rightly said, date has to be the majority when they have approved. That is
Yes.
one. But many a times what happens is that the resolution is left to be included in the noting by way of noting in the next minutes. So that has to be included in the board minutes, in the following board minute, that so and so circular resolution is passed and was approved on so and so. Sometimes at the meeting, it so also happens that the director say, no, these wordings are not right. We should amend it. So technically, it is not possible unless the board wants to, uh, revisit the resolution and amend it. Your view, Sudhakar ji?
Yeah, I agree with. In fact, see, whenever a resolution is there, that resolution, the way it is proposed, and if it is passed, then you cannot amend that resolution once again. You have to resign the resolution, and a fresh resolution is to be passed at the next board meeting.
Absolutely.
And similarly, in case of a resolution circulation, by merely passing by the date when the resolution was passed, unless until more than one third of the board has passed that resolution. Well, either way, they have to vote for. They might have voted for or voted against. Once more than one third of the directors voted for the resolution and it is passed by the majority, then only you can say that is the day on which the resolution is passed. In fact, it is very clearly explained in the guidance note. To give an example, that suppose a board is having, say, 10 directors. One third of the 10, it is 4 directors. So, unless until that 7 directors have voted for the resolution, and out of the 7 directors, 6 have approved the resolution, that particular day it is passed. Say, for example, you have proposed the resolution on, say, 1st of September. And the last date, what you have given earliest to earliest, it has to be passed before 6th of September. And on 2nd September, 6 directors have approved the resolution out of the 10. Is it the date? Answer is no. On, say, the last date, that is the 5th of September, another director has voted and he has voted against the resolution. Or say 5th of August, September or 4th of September, he has voted against the resolution. That will be counted as the date on which the resolution was passed by circulation. What is the reason for this? Because one third of the board has the right to insist that the resolution proposed by circulation is to be passed only at the board meeting. So till the time that one third of the board of the more than one third of the board of directors vote for that resolution, you cannot take the resolution passed by circulation. That is the logic and rationale behind that.
Yeah. Thanks.
Yeah.
Now, another thing is when you actually said the circular resolution is to be taken note of in the next board meeting. I have also seen invariably in some companies, this was actually missed out. But what they have done, they have taken the same in the next board meeting.
No,
But
it won't be.
ROC has taken
it
very
is a
serious.
non-compliance. It is a non-compliance.
ROC
See,
has taken
resolution will be valid. No, resolution will be valid. That is no doubt about it. But it is a non-compliance. That non-compliance will be dealt with separately.
I am coming to that only because in those cases, ROC has actually held it is a non-compliance. So when you are actually having a checklist, this is one of the checklists which should be included. What is to be done? That is another thing which is called for here. Yeah.
Okay, so the next topic comes as the minutes, wherein so the Act provides us to make the minutes of every board meeting or the committee meeting. However, the Act does not tell us how the minutes are to be prepared. So the Secretarial Standards does that job for us in a way to tell us what are the contents of the minutes that needs to be mentioned very specifically and makes it a proper minutes. So the basic particulars which needs to be mentioned in the minutes are the serial number of the board meeting, which has already been given in the agenda item, the type of the meeting, it's a board meeting, or if the meeting is being convened at a shorter notice, same needs to be mentioned. Name of the company, day, date, venue, time of commencement, and time of conclusion of the board meeting, or the committee meeting rather, are required to be mentioned as the basic particulars. And the details of the directors, I needs to be mentioned that we have already discussed in the quorum that the directors, the chairperson, company secretary, any invitees who were present for any particular agenda item as well needs to be mentioned wherein for which particular agenda item they were present by either physically or electronically, or if any directors has sought leave of absence, that needs to be clearly mentioned in the minutes. So also along with that, I mean, if any director is interested, disinterested, for that particular agenda item, if someone has recused the meeting for any particular agenda item, that needs to be mentioned where in the minutes itself. It should be fair and the correct summary, the contents of the minutes, in a way that the proceedings of the each agenda items, it is not a transcript. The minutes is not a transcript wherein each and every word which has been said by the directors or anybody in the meeting needs to be mentioned. However, the intent of the discussion, if there is any dissent, any approval, which has been the main part of the minutes should form. And as sir has already mentioned in the start of the session, that the minutes shall be written in a third person language and the past tense. It cannot be, minutes cannot be like in a present, made in a present tense. However, the resolutions which has been mentioned in the minutes, that can be in the present tense. Wherever the resolutions are passed, the text of every resolution passed, along with the names of the directors, if they have dissented or abstained from voting on any resolution, needs to be mentioned, along with the reasons, if there is any dissent for any resolution. And if there is, we have discussed this, if there is any interest of any director, that needs to be disclosed, and they would be not form part of the quorum for that particular agenda item to be discussed. There should be separate minutes book for the board and the committee meetings that needs to be maintained, and the minutes can be maintained in a electronic or physical mode both. However, if there is an electronic mode, the time stamping needs to be done, so that, because we'll be discussing the timelines, how the minutes are finalized, so that needs to be clearly adhered to. And all the pages of the minutes are also needs to be consecutively numbered, and there cannot be any tampering, pasting, and in the minutes book is allowed. I mean, if any sometimes sticking up any page, removing any page is not allowed from the minutes book. If there is any board meeting which has been adjourned, it should be clearly mentioned in the minutes where that the particular meeting was adjourned. And as we have discussed, the commencement and conclusion time of the meetings needs to be clearly mentioned. Now, how the minutes are finalized from the draft to the signature state. So the first draft is circulated within 15 days from the conclusion of the board meeting to all the board members or the committee members for their comments. And within 15 days, whenever it is circulated, they are given 7 days time period to provide their comments. If it is, there has been no response, it is deemed that they have given the approval for the draft. So the minutes are required to be entered within 30 days from the conclusion of the meeting. So minutes needs to be finalized within 30 days, and no changes can be done in the minutes post 30 days time period once they are entered in the board, in the minutes book. After that, the chairman of the particular meeting or the next meeting chairman, they need to initial on each page, and last page needs to be signed and dated for the signing of the board meeting. And post the minutes are signed, the certified copies of the signed minutes are required to be circulated to all the directors within 15 days from the signing. This is a point where a lot of companies makes non-compliance. In case they do not wish to do so, they can take a waiver from the board in a board meeting from the board of directors. If the company has a waiver for circulating the signed minutes, then it is okay. Otherwise, it is a mandatory requirement to circulate the signed minutes with all the directors.
So, Sakshi, one point on the minutes. Recently, I have been to few unlisted companies wherein the company secretary and the senior folks also said that we don't do any minutes, we just get it done on AI. So that's a little dangerous trend. So my suggestion to my fellow professionals would be that while AI can be used for betterment of language, but that should not, as Sudhakar ji has also mentioned, that minute should not be jargoned. It should be precise and to the point. And when we rely too much on AI, our own ability may over a period of time will reduce, and the management may also think about us that are we really required. So AI is a tool and it cannot be the solution for everything. In fact, recently when we have seen that the some chartered accountants have taken out audit report from AI and they had forgotten to remove the baseline wherein the chat GPT etc says that do you need any further edit on that or a better format etc, and the CFOs and the likes have signed, including the auditors have signed. Of course, the actions have been taken later on when it came to social media. So all this can happen, and AI does not even look into the case laws. Some case laws given by AIs were taken in the minutes, and when the matter came to the court, those cases didn't exist at all. So therefore, use of AI should be only for language improvement or to help and not to outsource our job to AI. That's a humble suggestion.
Yes, Akshay, can you please go to the previous slide? Now I have one or two points to add there. So here, in that, this one. See, in the attendance details, what you need to do is that first that, in attendance, the board of directors are there. I mean, attendance, when you say that, first of all, you have to give the board of directors, then you have to give the invitees, and then in attendance, the company secretary. Apart from the company secretary, and the directors, everyone and anyone, they will form part of the invitees only. That means whether it is a CFO of the company or a president of the company or whoever it may be, if they are attending the board meeting, they have to necessarily receive an invite from the company secretary, then only they can attend the board meeting. They don't have an inherent right to attend the board meeting other than the directors. In addition to that, it is also mentioned that the time of commencement of the board meeting as well as the conclusion of the board meeting. These things should not be taken lightly, and you have to ensure that the conclusion of the board meeting is properly recorded. Because several times it may so happen that your directors might be celebrities or your directors might be eminent people. You are showing that the minute the board meeting is closed at say 6 p.m. in the evening, and 5 p.m. in the evening he might be addressing some other forum, and he is there on the social media already, and you are showing his presence as a part of the meeting, then you will be in trouble at that point of time. This is a very important point one need to see. Another thing is that the minutes of the previous meeting, I mean, with all due regard, several people doesn't know that the minutes of the previous meeting is only there mere for noting. They don't need to be confirmed. They don't need to be approved. They don't need to be ratified. Only to be noted. That's it. Without understanding, several people used to write several things as far as the minutes of the previous meeting is concerned. The third part of it is that the signing of the minutes of the previous meeting can be signed at any point of time before before the present meeting. It may be signed by the chairman of the previous meeting, even before this meeting also. Noting is only a customary. Now, some people may ask me the question that how, when he has signed it, if any alteration is to be done, how it is to be done. Whether he has signed it or not, it is immaterial. You cannot alter the minutes after 30 days. When you say that minutes are to be recorded within the 30 days, means whether it is signed or not signed, it is immaterial. You cannot alter that minutes. If and all any alteration is to be done, that is to be done by way of a separate discussion in the next board meeting only. Now, suppose, for example, the previous chairman is not there. Can the current chairman of the board can sign the previous minutes? Answer is yes. The current chairman of the board meeting can sign the minutes of the previous meeting also. Then comes the question that can the minutes of the board meeting be written in any language other than English? Because this question also has come and this has been addressed in the guidance note that you can maintain the minutes in any language you feel like. However, whenever you are filing the extracts of the minutes in the ROC or in any before any court of law or before any regulator, you have to give that particular meeting as well as the translated copy duly certified by the company secretary. You have to file it with. And finally, the draft minutes of the meeting are to be circulated within 15 days. Within 7 days, the directors have to give their observations and all. Now, if they are not giving an observation, if they are keeping quiet, that will be deemed to be their assent. When I trained the directors, I used to always caution them that in the good olden days, used to take a alibi that I am not there at the particular board meeting, so I am not a party to the decision taken by the board. And here also that even if you are not attended the board meeting, still you can express your dissent. Even if you are not attended the board meeting, please note that you can express your dissent, and the chairman is under obligation to record your dissent. Even if you are not attended the board meeting, still you can give your observations based on the draft minutes as well as on the agenda. Those observations may be taken on record by the chairman. Yes, no doubt it is the discretion of the chairman to ensure what has to go as a part of the minutes. If a director give a speech of half an hour, he cannot insist that verbatim it is to be recorded in the minutes. Of course, in government companies, it does happen. They record everything comprehensively. Other than government companies, it is the chairman's discretion what to write, what not to write. But as far as the dissent is concerned, he is obligated to record the dissent. Then question comes about the abstinence of the director from the voting. If at all any director is abstained from voting, that is to be recorded which director has abstained and for the reason thereof. If you say in the SS-1 it is mentioned, the reason also is to be recorded what he has doing that. So you need to ensure that the director, when he abstained from voting, he has to give a reason for that, and that reason is also to be recorded. So please ensure that in case the minutes are not properly recorded as per the law, and that minutes may be defective, and defective minutes are not be present before the court of law as an evidence. So it is the company secretary's responsibility to ensure that minutes are recorded properly.
So we have already discussed this. Sir has quietly mentioned that, but still the minutes once entered within 30 days cannot be altered. Any alteration in the minutes as entered shall be made only by way of express approval of the board at its subsequent meeting and in which the minutes are noted. And the fact of such alteration shall be recorded in the meetings of such minutes of such. Now the next point which comes is the inspection of the minutes.
Sakshi, one more thing also, that if I'm not wrong, every page is to be initialed and the last page is to be dated.
Yes.
And the full signature of the chairman is to be there, and also the place of the meeting where he is signing the minutes is to be also recorded. I
Yes,
think
sir.
it is not there in your this thing, but it is there. Place also you have to mention.
Yes, please. Yes. So next is inspection of the minutes. Because as sir has mentioned initially that it has not been part of the Companies Act where who can actually do the inspection. So it has been clearly defined in Secretarial Standards that the minutes of the meetings of the board or any committee can be inspected by the directors. Any member of the company is not entitled to inspect the minutes of the meetings of the board. Any the professionals in the company wherein like they are the auditors, the PCS appointed by the company, SEC auditor, statutory auditor, or the cost auditor or internal auditor of the company can inspect the minutes for the performance of their duties, and inspection of minutes can be provided in the physical or in electronic form as requested by the directors or the professionals, but no people other than that can have the right to inspect the minutes of the meetings. There are certain case laws which is, with respect to the minutes specifically, in the case of Man Industries Limited, the Bombay
Just
High
one minute, Sakshi. One minute. Sakshi, before you go with the case laws, just go back to the previous slide. So as I was mentioning, as far as the minutes are concerned, the inspection of the minutes, who can inspect the minutes? As Sakshi has rightly mentioned that only it is the directors who can inspect the minutes. And plus, apart from that thing, auditors may inspect the minutes and the regulators may inspect the minutes. I reiterate that auditors don't have the right to ask for a certified copy of the minutes. They can ask only certified copy of the extracts of the minutes at the most. Then question comes that suppose if a director had joined today, can the director have ask for the minutes of the previous meetings? Can he inspect that? Can he ask that to the company secretary, I want to see the minutes of for the last 1 decade. Please show me that. In fact, as I was mentioning under the Companies Act 1956 or in 2013 also, it is not clearly there in the Act as such that directors have a right to inspect the minutes. Only directors can inspect the books. And minutes are also a part of the books under the definition, and that's why they have a right to inspect the minutes. But nowhere it is there that whether a director can inspect the minutes of the previous meetings before his appointment. Similarly, can a director inspect the minutes of the meetings what he has attended post his resignation? That clarity is not there, but that clarity has been given in SS-1. If I am a director appointed today, I can ask the company secretary to show me the minutes of all the previous meetings also. I have a statutory right. It is not a, favor or a charity of the company or the company secretary on me. I have a statutory right. Similarly, in the good olden days, several times it used to happen that once a director resigns, if he wants to inspect the minutes of the meeting, he attended the meeting, and because he wants to protect himself in the court of law for give him the copies of the minutes or inspection, then he was to approach the court to get directions to the company so that they will allow him the inspection, they will allow him copies of the minutes. Whereas now the director has a statutory right. A director has a statutory right that he can inspect the minutes of the meetings during his tenure, and he can also ask for a certified copy of the minutes held during his tenure. And again, the same thing as I mentioned to you, for whatever the purpose it may be, and the company secretary are obligated to provide him that. In fact, whenever I say that SS has done a great service to the professionals as well as to the directors, this is the major thing according to me, that the inspection of the minutes, that right, statutory right, what has been provided with to the directors, because I was the person who have seen that several directors used to struggle under the old act and prior to SS-1, which has been mandated by the act as such. And those difficulties to a large extent have been addressed in this SS-1 and have been removed also, those issues. Yeah. Go ahead, Sakshi.
Yes, sir. So in the case laws, basically the Bombay High Court held that minutes are not conclusive evidence of proceedings, they are only prima facie evidence. Once produced, the burden shifts to the party destructing the accuracy to prove otherwise, but they can still be displaced by contrary evidences. So, I mean, here the relevance to the SS-1 practice comes as it confirms why the quality and the why the minutes matter and not their existence. I mean, if the minutes are very well drafted, timely signed, minutes carry real evidentiary weight, and vague or late ones are far easier to challenge the successfully. Similarly, in the other case of M. Aramachandra Bail versus M. R. Kania, it has been held by Madras High Court that merely recording a person's continuance as a director in the board minutes does not by itself amount to valid appointment under the applicable provisions. The minutes reflect what was decided. They do not cure a defect in how it was decided. Accordingly, here a caution of the practitioners is that the minutes cannot retroactively validate a process that was not actually followed. For example, if the meeting was minutes were properly made, however, the meeting was conducted without presence of a proper quorum, or the appointment was not done as per the requirements under the Act. However, we make the minutes, it does not really ratify that particular appointment or the decision taken at that particular meeting as the valid one, because all the requirements needs to be followed along with the minutes itself. So in the minutes, all these things needs to be properly mentioned, wherein the quorum is present, if the proper quorum is present, and if the particular agenda is being transacted for the appointment or any other thing for that matter needs to be really minutized in a proper manner, then only it would act as an evidence in the court of law. So with respect to the records preservation and their disclosures, the minutes needs to be preserved permanently. The notices, agendas and papers are required to be preserved for 8 financial years. And the custody of all these papers should be with the company secretary, and if there is no company secretary, a person who has been authorized by the board of directors to do the same. If the board of directors wants, they can add on to these timelines what has been given, but it cannot be reduced. Similarly, companies are also required to give a disclosure in their board report that a statement wherein it has been mentioned clearly that the company is complying with the applicable secretarial standards. It is a mandatory requirement for them to be added in the board report, and which makes the adherence making SS-1 adherence a disclosed governance matter, and it is not just an internal process. So if there is a non-compliances of SS-1, because it has been discussed multiple times if it is mandatory or not, though we have discussed this, it is a mandatory requirement. If they, in a case, the companies are not really complying with the secretarial standards, then they're under section 118 subsection 11 of Companies Act 2013. The contravention can attract penalty on the company, and along with that, every officer in default, as under the act, company would be liable for penalty of 25,000 rupees, and then every officer on the company who is in default shall be liable up to a penalty of rupees 5,000. It invalidates the action which has been taken by the board if the decisions has been done without following the proper secretarial standards, which means the quorum notice or anything which we have discussed. The validity of the decisions which has been taken in the board meeting becomes invalid. The secretarial auditors are also required to qualify the audit reports for non-compliance with the secretarial standards. And same as required to be mentioned in the MGT 8 as well. If the company is not, if secretarial audit report is not mandatory on the company, if MGT 8, which is annual return certification, is mandatory, then non-compliance with the secretarial standard needs to be mentioned therein. It also brings the regulatory and reputational risk to the organization, which is majorly for the listed companies, but for the private or the unlisted companies as well, it brings the reputational risk to them. Also, the directors who are relying on improperly convene the meetings, or if the minutes are not being properly minutized of any meeting, then during the due diligences or any other, if anything happens later on, it becomes the director's liability as well. We have discussed this. There is a penalty. They are liable to penalties, the directors as well. Now we have discussed, the major parts of the secretarial standards about what it has been given, their objectives, the impact of non-compliances. Now to understand how it is really helpful, it is safeguarding the company secretarial standards. So they provide the legal defensibility to the organizations. If the meeting was conducted with the proper manner, proper notices has been sent, so the documents become legally defensible, and they can be used as an evidences. Decisions what the directors are making are the informed decisions, because if the notices are sent well in advance and all the timelines are being followed, it is an informed decision which shows the company is not doing anything which is not with the malicious intent, or anything which is not wherein like they do not want the directors to be involved in. And according to that, the stakeholder confidence builds in the organization if they're following the secretarial standards, because at the time of generally at the due diligences or the seed funding rounds, whenever there is a new investor coming in, so it brings the confidence in those investors as well, that the company is following all the processes very well, and it shows the business continuity as well, in a way that there are companies following proper rules for the quorum. If an interested directors, they are sent out of that meeting for that discussing that particular agenda item. So the decision making is done very well in advance and very well informed, so which gives the very good business continuity to the organization.
So Sakshi, one point here, many unlisted companies don't have the authorized capital which is mentioned for CS.
Yeah.
Or the 10 crore limit for audit committees, etc. So here the play of the, the role of the professionals come into play. That how we guide those companies, how we ensure that the compliance is done. And it is here where SS-1 helps, Secretarial Standard 1 helps, that if we follow this, then probably the concerned people who are taking, of the company, they would be protected. That was a limited point. And eventually, as you rightly mentioned, when the company things improve and they go for listing and some investor enters, all this will help the company to gain investors' confidence and regulators' confidence as well.
I think, Sakshi, you'll have to wind up. It is already 1 o'clock.
So
You'll
it
have
is
to
a
take few more
last slide.
questions.
So
Yeah.
basically, the SS-1, to summarize, SS-1 safeguards the company, the professionals working in the company, the CS who are working in the organization. If the directors are doing something which is not right as per the law, but the CS is following the complete proper secretarial standards, it safeguards all of them from the penalties, and documentations are done properly. So it is any which ways is not a guidance. It is a mandatory thing which needs to be followed, and accordingly it is providing us the details which has not been clearly mentioned in the law for all of our sake, organization and the professionals. Yeah, thank you. So now we can take up the questions.
Excellent, Sakshi. Very good presentation. I really appreciate for bringing up the various points nicely captured. You can stop sharing the screen.
I'll do that. Thank you.
Multiple questions, I think, Bala sir.
Yeah, let us take that. Agenda paper after 8 years can be destroyed, needs a board permission, or it is under the Companies Act allowed.
See, as far as destruction of records are concerned, Companies Act is silent about that. And minutes are to be maintained in perpetuity, but agenda papers, how long they have to be maintained, is nowhere mentioned. Considering the importance of agenda and backup papers, my advice to all the participants is that together with the minutes, the agenda papers will also play a very key role in that. So advisable to maintain it as long as possible. Any point of time, if you want to destroy the agenda papers or any other records, you need to have the board permission for that. Please ensure that it is properly inventorized and then got the approval of board before destroying the same.
It was mentioned by Mr. Sudhakar that the auditor cannot ask for the certified copy of the minutes. They can only ask for the certified copy of the extract of the minutes. What is the difference between the minutes and the 100% extract from the minutes?
Extract doesn't mean 100% extract. Extract means only the parts of the minutes. If you ask for a certified copy of the minutes, right from A to Z, you have to give it. When I say extracts of the minutes, the auditors can ask. They may ask the resolutions. They don't need to be given the backup note for that particular resolution.
Correct.
And similarly, you will give the extracts of the board minutes only to those people on need to know basis or need basis only. Why you will have to give it to the auditors and secretarial auditors is because they have to undergo the peer review. At the peer review point of time, that peer reviewer may ask for some kind of a backup papers. So for that, you may ask for the resolutions, not anything else. So without understanding the gravity of that, what people normally do is that they give the extracts of the minutes, certified copy of the minutes, the auditor asks, then they give it. At the same point of time, I also to a large extent, if at all you are giving in the what's called by way of an email, never ever give in Word format, always give in a PDF format only, so that no tampering is possible there.
So absolutely right. Just to add to what Sudhakar has said, invariably what happens when a certified copy of the resolution is asked for, it's given with preamble. It should not. We should avoid that. It's only the resolution which is to be given and not the preamble, which is the internal discussion of the board.
Can the auditor ask the CS to send the minutes by the mail for audit purposes, listed or unlisted company?
I told already about that. No.
Can the minutes be signed at the next board meeting, or it should be within 30 days of the meeting? That I already addressed, I think. Who will sign the notice for the first board meeting? That also I think you addressed. Where I doubt here, madam, know that proxy cannot be counted for the quorum, but as per the Companies Act, proxy is not allowed in quorum. Can you clear this point? But if the board meeting is within 30 days, can we mention the approval confirmation of the minutes of the previous board meeting?
I think the proxy she must have meant is for general meeting. In board meeting there's no proxy. Probably what she meant is invitee.
Sir, it has been clearly mentioned in the guidance note as well, like the proxies, as we do generally, someone in place of director whose representation, who is giving the representation of director is not allowed for the board meetings. It is in the general meeting.
Alternate director.
Yeah.
Chairman of the board meeting could not sign the minutes for the 3 consecutive board meetings. Subsequently, the chairman retired. Whether the new chairman can sign all those minutes.
No.
There is a non-compliance. It cannot be done like that.
Whether the minutes should be circulated within 15 days, even for private company attended by the directors in present.
Yes.
Circulation of the minutes to be all the director within 15 days. No. Yeah,
See, let me say one more thing also. Let me say one more thing. A director who was present at the meeting, he might have subsequently resigned, or his tenure might have been over. Still, you have to provide the draft minutes to him. He can give his dissent, he can give his observation, even if he was not a director on that particular day, because at the date of the meeting, he was a director.
For AI use, I think somebody has given a compliment should be restricted drafting and the language improvement only. If the resolution by the circulation needs to be confirmed or simply noted in the next board meeting, it should be noted, in my opinion.
Yes.
Sir, we are a private limited company where the board consists only 2 directors. We are passing the resolution to authorize one of the director to sign NSDL application. Should the director be deemed to be interested in that item? Could you please provide a statutory provision court cases available on the situation? In my opinion, there should not be interested party in this case.
No, it is not an interested party.
If chairman is interested in the particular item of the business or how they incorporated the board minutes to chairman in the board meeting. Now, generally what happens, the chairman is interested for the meeting. He actually temporarily passed on his mic to the other person who is holding a chairman for that particular item. When that particular item is discussed again, he hands over the mic back to the chairman. So recording should be done accordingly.
But in case of a private company, he can disclose his interest and he can continue to be the chairman. Only in other companies, what the procedure you have mentioned is correct.
Can the board meeting be convened without the written notice? I think this we elaborately discuss about. In virtual meeting, signing of the attendance register may be treated as signed.
No, in case of a virtual meeting, the director who has attended in virtual mode, in the attendance register, you will mention that he has attended in virtual mode, and attendance register is to be signed by, countersigned by the company secretary. So he is authenticating that the presence of concerned director by way of a virtual mode.
Correct.
Correct. I think I read out on the last. The whole question is, what if all the director present via VC, digital attendance register in the board meeting, any suggestion for the meeting of those VC in virtual meeting, signing of the attendance register may be signed. I think you answered that actually.
Yeah.
Is the CS required? Is the CS required and responsible to cross-check the declaration by the director of his interest, non-interest in the particular resolution, or relies solely based on his her declaration?
See, based on the records and based on the information available with him, that he has to see whether the director's conflict of interest is there or not there. So you cannot merely take the declaration only on the face value of that. Because if the information available or documents available with you take something else, then you have to ensure that conflict of interest properly.
Yeah, because every time directors gives his interest actually either in the beginning or whenever the changes taking place. I think Company Secretary has a track of it. Especially it is so when you are approving the contract and agreement in which directors are interested, he has to check back actually. Yeah. How should the serial number to the board meeting be assigned? Is it starting from one from the first meeting and continuing the number across the users, or can we assign serial numbers fresh starting from first in each year?
I request this concerned person to make some effort to read the guidance note. It is clearly mentioned in the guidance note how it is to be addressed. Let him read the guidance note.
Consecutively
first.
numbered.
A company is not held the board meeting in a year. In this case, is it adjudication matter or compounding matter? Further, MGT 7 is enabled to file with a 0 board meeting when board meeting are not held in a financial year. However, AUC 4 annexure extract of the board report is not enabled. In such a situation, how the return can be filed?
This query has nothing to do with SS-1. No, this is a very complicated one. If in case they want, they can approach method for that.
But one thing is that it's the adjudication matter, it is a non-compliant, you need to go for the adjudication. That's it.
Correct.
Yeah.
Who can sign the agenda of the meeting? ask Sakshi to say, okay, who has signed the agenda for the meeting that we had discussed elaborately. Is the meeting has been scheduled to be held physically at RO with an option to attend virtually with the directors and the meeting virtually? What is the considered to be a venue? This also be discussed. Statutory auditor or second auditor may ask the copy of the copies of the minutes for audit purposes. Is it okay to provide them with the same? That also be addressed actually.
So it is
Authorities
clarified on this, yes.
Yeah, authority summon what will happen when the company has no CS. This also we talked about it. For how many years the electronic records of the meeting held through BC need to be preserved? I think that also you actually answered this questions.
See, please, one thing I would like to mention is that electronic records and physical records. Recently, somebody was asking me that they maintain the minutes in the what's called I mean, they record the minutes in laptop or something like that, and then they're in the servers. That is not electronic maintaining. Electronic means that there is no the paper at all in between. You know. Suppose if you are typing in the laptop and then you are taking the print and getting it signed manually, that is not electronic records. That is only a physical record only. Number two is that whether it is electronic or physical, the records maintenance is concerned, it has to be as per the law. It is whether the minutes are to be in perpetuity, annual returns are concerned, that is for a period of 8 years, so on and so forth. Okay. And yeah, that's it.
I have a question about the recording of the meeting. If one director attend the meeting through AVM and the rest director attend the person, should we need the record of the meeting? I think it is addressed actually. Is it obligatory to the minutes printed on the minute paper signed by the chairman or kept it in the bound book, or it can be maintained on A4 paper and kept it in a archive file?
Please remember that whether you maintain it on a A4 paper, the GSM is suppose 40 GSM or 60 GSM or 100 GSM. Please remember one thing, the minutes books are to be maintained in perpetuity. Sometimes the companies may be 100-year-old companies also, like Tata Group is having some 100-year-old companies. So you need to have the old records. You cannot simply say by that paper fat gaya, and all those things, that nobody listens to that. So ensure that proper bound paper is there on which you are engrossing the minutes. Number one. Number two, also let me take this opportunity to say that minutes are to be recorded within 30 days. That means you have to engross that minutes in the minutes sheet and keep it in your file. Even if it is not signed, no problem. But if the regulator comes for an inspection and asks for the minutes of the last meeting and you say that I'm going to take print and I will give it to you, it is a non-compliance. Please remember that.
In India, most of the companies being a family-owned private companies and a few public companies, SS-1 is hardly followed. Does it mean poor governance? Let me tell you one thing. Whether it is a private company, family company, public company, unlisted company, all companies are encountered the Companies Act. We are bound to follow the provision of the Companies Act, irrespective of whatever the type of the companies. Anything which is not followed is a non-compliance. That's it. There is no question of family, company, and otherwise. And board, committee, and general minutes be numbered financial year wise after obtaining the approval of the board. So same question about the numbering. Somebody actually said that, introduction with the delayed, we are sorting the topic late, etc. It should be brief, etc. Let me tell you one thing. It all depends upon the topic, so the importance of the topic. And another thing is that we are like hearing actually from the expert people, their experiences, their experience. It's always said the wise man always learn from the experienced people. So this topic is of very much important, and we were definitely required to know why SS-1, because there are questions have been raised actually when the Companies Act is there. Why SS-1? Is it supplementary? It is mandatory? It is complementary? Is it over and above? All those questions was there. In order to get our mind clear, yes, the introduction, it was necessary. It all depends upon the topic and it is important. There is no question of introduction being too long, too less, etc. And all. Anyway, topic is already taken, which I wanted to bring to the notice of the participants. That's all. I think questions are done with. So
There's
now
one
let me
hand
see
raised, Raj Garg.
any hand risen is there. Let me see that.
Hmm.
Yeah, I can see one hand risen actually. Raj Garg. Raj Garg, are you there? If you are there, you can unmute and speak. Raj Garg, are you there, Raj Garg? There is no response.
Sometimes by mistake also it get raised. So maybe.
Yeah, possible. There are some more questions actually has come here. Our company originally registered under the Section 25 of the Companies Act 1956, corresponding to Section 8 of the Companies Act. Regularly approaches the institution for the CSR funding. During the diligence, they request the copies of the newly signed minutes and related agenda papers. Is it appropriate to show these documents or any specific precautions are approved to be taken. I think it is elaborately addressed what is to be given, what is not to be given.
Yeah.
Sir, company has appointed as a director whose role is the factory occupier and he cannot take part in the financial matters of the company. This is mentioned in the resolution passed for appointing him director. Whether the director can vote section 186 approval of the company, since section 185 requires unanimous approval.
No, you cannot restrict the director's rights, duties, responsibilities, etc. with or without his consent.
Once the director is actually appointed by the board of directors, he is having all the rights and priorities which are actually granted under the Companies Act. But another thing is there, we cannot overwrite anything over and above the Companies Act what is already granted. That is another thing. Because only thing is here from the question, what I can see is a director only can be appointed as the occupier of the factory. So by virtue of that, you decided to appoint an occupier. That is why you probably appointed the director. But that does not mean he does not get the right. That's what I feel in this case.
That's right.
Because there's a famous case, which has actually come, Supreme Court judgment has actually come there. Can the board authorize anyone to issue agenda along with the notice? I think this we elaborately discussed actually. How to directors approve the increase in the sitting fees of the committee board when most of the directors may be interested?
Go to the shareholders.
How to get the sign in the attendance register all the director person which are BC? That we already discussed. I think that's all. I'm done with all the questions. I think hands are not risen. I think we can close down the session at this time. It's already 1:20. Sudhakar, your last words you would like to hear?
No, my last words are only, as I mentioned to you, that SS-1 as well as the guidance note, these are most important documents. In fact, at the time of induction of the directors, I always used to say the directors, whenever I train them, to ask the company secretary to provide them 4 things. So here I am requesting the company secretaries to give it to the director these 4 things. Number 1, Chapter 11 and Chapter 12 printed copies of the relevant sections. Code of Conduct, that is Schedule 4. Copies of SS-1 as well as SS-2 and the guidance notes thereof. Please give it to all your directors, these things, and ask him to get him familiarized with this. That is very, very important thing. Unless until your director is educated, he is of no use to you, the company. And it is your responsibility as a company secretary to educate the director, if not already educated. Thanks very much.
Thanks a lot to everybody. With this, we will close the session. We will meet in the next session. The next week, we'll discuss further on this. Thank you very much, Sakshi. Once again, excellent presentation, excellent deliberations. I am personally thankful to Anil Khatri and also, as usual, our expert Sudhakar. Wish you a good day. Thanks to all participants. Thank you.
Thank you very much.
Thank you. Thanks all.